Hi, let's do an exercise distinguishing between actual and constructive notice. Notice to legal title. When property transfer takes place, there are two types of legal notice that may be given: actual notice or constructive notice. Whether you are the buyer or a seller, it is a good idea to give notice to others that the exchange of property has taken place. For the seller, it is in the interest of being relieved from any liability that the ownership could potentially bring. Let's say someone was hurt on the property after title had transferred from one person to another. Then the seller would want the public to clearly understand that he or she is no longer responsible for anything that happens on the property. Both methods are considered legally sufficient in the eyes of the law that notice was given. Actual notice. Actual notice can come about through several ways. Participating in an event, such as being a party to a closing, provides direct and actual notice that transfer has taken place. This participation comes from participating in the event through reading, hearing, or seeing. Actual notice has occurred when an individual was directly notified about an event, such as when served through personal service of the court. For the buyer, let's say that the person wants to engage the services of a contractor. The buyer would want the contractor to know that the buyer is now the true owner and has the right to make changes and hire the contractor. There are two ways to give notice to the public that something has taken place, in this case, property being transferred. This can be through actual notice or through constructive notice. Personal service, or being served, of court documents is another common method of delivering actual notice when the person accepts the documents. Constructive notice. Constructive notice is a form of notice that is easy to obtain through inquiries, such as seeing a notice in a newspaper or a recording with the clerk of the court. Recording something in public records is a means to give constructive notice. For example, the prospective purchaser of a property is presumed to know the current legal status of a property from documents recorded with the clerk of the court. These documents are available for public inspection, including inspection from the prospective buyer. A notice of court action published in a newspaper is also considered constructive notice. For example, Azure Realty Corp. is registered with the Florida Division of Corporations. However, All Florida School of Real Estate is also registered as connected to Azure Realty as a DBA, doing business as. Before the Division of Corporations would allow the registration of our DBA, we had to publish in a newspaper a legal notice about use of the name. Regarding real estate transactions, all documents recorded with the clerk of the court are binding as legal notice having been sufficiently given. However, it is not required that a deed be recorded in order for the deed to actually be considered valid. There is a difference between a valid deed and the notice of the valid deed. Acknowledgement. Deeds do not have to be recorded with the clerk of the court to be valid. However, deeds must be acknowledged by the grantor, and this acknowledgement must be notarized in order to record it. An acknowledgement is the assertion that the deed was signed voluntarily. To be notarized, the signer must sign in front of the notary public and declare that he or she has signed the document voluntarily. The notary will check that the signer understands the document that is being signed and ensure that the person is not being coerced into signing the document. Leys pendens. Lenders provide constructive notice of a foreclosure by filing a leys pendens notice in the county where the property is located. The purpose of this notice is to bring the pending foreclosure to a buyer's attention in case the owner attempts to sell the property.